Hi. If you had ever filed a suit in a civil court, the result of a suit, which is the language of the court, in a common knowledge, it is called a case. A civil case is called a suit. When you file a suit, you will be called plaintiff, and the other side or the opposite side will be called the defendant. The result of a suit will be in the form of a decree, or it will be dismissed. If it is in the form of a decree, procedure doesn't end there, because you cannot do anything with a decree. You have to execute the decree. Then the plaintiff or the person who comes to court and files the case will become the decree holder. The defendant against whom the case was filed will become the judgment debtor. In other words, you can call the decree holder as the judgment creditor and the defendant as a judgment debtor. Generally, defendant becomes the judgment debtor. Now the decree has to be executed. Invariably, decree is always executed by the decree holder or the plaintiff. For example, if the plaintiff gives money to the defendant and plaintiff gets a decree in his favor, that's the court gives a direction, an order to the defendant to repay the money to the plaintiff. So the case was decided in favor of the plaintiff. So now the plaintiff becomes the decree holder. So invariably, plaintiff has to file an execution petition against the defendant or the judgment debtor. So the plaintiff, in the capacity of a decree holder or a judgment creditor, will file an execution petition against the judgment debtor or the defendant, who is liable to repay the loan taken from the plaintiff. And broadly speaking, there are 3 steps to recover the money from the defendant or the judgment debtor, which is by way of an arrest, by attachment and sale of immovable property, and attachment of sale of movable property. These are the 3 major steps in a civil procedure code to recover your money or to execute the decree. At the end of the proceeding, every remedy, every problem in this world settle down to money. And money is in the form of a movable property or an immovable property. Therefore, movable property and immovable property are attached and sold. In execution procedure also, there are 2 steps. One is the attachment. Court will attach the property. That is a separate procedure. I don't want to share the procedure with you right now. And the next is sale. Without attachment, sale cannot be done. So attachment is one step, sale is the next step. So first, property is attached. For that, the decree holder will file an application or a petition in a court, in the same court, which is called the executing court. And then the property gets attached. Once the property gets attached, another application is filed to sell the property. That is again a different procedure. So both these applications, both these steps, both these procedures, both these proceedings are at the instance of the decree holder only, not at the instance of judgment debtor. Debtor is always liable to creditor. But there could be instances where decree holder can keep the execution proceedings pending at the stage of attachment. There could be hundreds of reasons for keeping the execution proceedings pending at the stage of attachment. Now, judgment debtor cannot sell the property, or judgment debtor cannot do anything with that property. For a loan of 1 lakh, a 1 crore property is also attached. Eventually, defendant will be liable only to the extent of 1 lakh only, not to the 1 crore. But 1 crore property will be attached. Defendant cannot utilize that property for other purposes. The judgment debtor cannot utilize that property for other purposes. At those circumstances, this video will come in assistance to you. Not only the decree holder, judgment debtor can also file an application and get a certificate from the court for mortgage, lease, sale of the property. Here, the decree holder only has the right to file an execution petition because he holds the decree. But if he plays any tactics, delay tactics, and causes suffering to the judgment debtor can also file an application for sale, mortgage or lease, subject to paying those proceeds into the court for the purpose of clearing the loan taken from the decree holder. In that process, judgment debtor has to obtain a certificate from the court that he is going to mortgage, he is going to lease, he is going to sell the property to pay the proceeds to the decree holder, to satisfy the decree holder or the decree. So there is always a remedy in the execution proceedings, even to the judgment debtor, not only to the decree holder. The judgment debtor also has a remedy. Is the sum and substance of this video. Thanks for watching. If you have any doubts, kindly comment.